international waters. Thank you, sir.
Thank you. Mani Sadasyagan, motion moved. Now, Shri Vivek K. Tankha, Mani Vivek Tankha ji, please.
Thank you, Chairman, for giving me this opportunity. I would first commend the ministry that you referred the matter to the standing committee, which was able to correct many of the mistakes which I noticed in the original bill. So a lot of mistakes have been rectified in this bill, but let me just point out a few things which may need your attention and some for humor also. You know, the original title of the bill was Anti-Maritime Privacy Bill, as if it's anti-maritime. It had to be anti-piracy rather than anti-maritime. So they changed the title on the recommendation of the standing committee, and now it's titled the Maritime Anti-Piracy Bill 2022. So that is a good thing which they noticed. Then as we proceed with the bill, in the definition, there was ambiguity whether the continental shelf is covered or not, because they were talking of high seas. And they did talk of the continental shelf. They changed that in the first provision itself. Another thing which I noticed was they had not notified which personnel would be authorized to arrest, investigate and seize in the continental shelf, Indian waters or high sea. This also has been rectified now in the present bill, and now you have defined who are the authorized personnel. This definition was not there earlier. And of course, the definition of piracy continues to be there. What I noticed again is, in the original bill, they had also covered ships with and aircrafts. The aircraft part has now been deleted. Now it's only ships. But while finalizing the bill, Honorable Minister, if you look at the explanation for which is explanation to 2I at the bottom of second page, explanation for the purpose of the clause aircraft shall have the same meaning as assigned to it in clause 1(2) of the Aircraft Act. This is a surplus. This is not required now, since you have deleted this entire bill from the ambit of aircraft. This explanation, maybe by mistake, has continued in the bill. Otherwise, it should not have been there. When you come to the offense part, whoever commits any act of piracy, now this act of piracy means the act of piracy as defined in the act. No issue. So, of course, there is no aircraft piracy now anymore. So that is why I'm saying that explanation is also not required. But what I am a little surprised that in clause 3, 2 proviso, and in addition, all shall also be subject to restitution or forfeiture of property involved in commission of such offense. Generally, if there are provisions of restitution and forfeiture, they also provide the procedure. Here, what is the procedure of forfeiture is not provided in this act. We have seen from 80s when acts were enacted and forfeitures were provided. Initially, it used to be struck down by the court as being arbitrary because there was no defined procedure. So maybe you will have to bring the procedure of restitution and forfeiture. And let me also tell you that the imprisonment part will continue to look very harsh. So there are many countries in this world who don't accept capital punishment. To name a few, USA, Kenya, Italy, Australia, Sri Lanka, and maybe others also. Now, the moment you bring capital punishment, all your treaties and conventions will go for a toss, because their jurisdiction, legal jurisdictions, don't accept death penalty. So I don't know how you will be able to align your clauses with their preferences, because if the two don't match, there will be problems between two countries' legal jurisdictions. Then coming to clause 7, I mean, where you say that the authorized personnel may either generally or on suspicion that a ship is engaged in piracy on high seas shall board such ship and arrest the personnel or seize the pirated ship and property on board. Now, this is what I am a little surprised. On suspicion, you are entering a ship. But you can only arrest a person if you are prima facie convinced that an act of piracy has taken place. You could also do it if there was an attempt being made, because attempt is also made punishable here. Planning normally is never punishable. The only provision in IPC where planning is punishable is dacoity. Planning a dacoity is a punishable offense under IPC, but planning otherwise is not a punishable offense. The problem that I see here is on suspicion you enter. You also arrest a person. You also forfeit, you seize his property. Now, what are you going to do with this property and with the person if there's no offense? How will you deal with him? This is something which you'll have to ponder over, and I'm sure it will be a lawyer's paradise to argue such cases in courts of law. Again, if we go a little further, you have rightly designated, you have rightly said that the central government, in consultation with the Chief Justice, will designate courts. Now, these courts are also courts of sessions. Question again is, when you have an overcrowded docket in courts, are you giving them extra judges for these offences, or it's the current number of judges who will also now be burdened with these offences and actions? So the problem is, in India, we don't see that, we have no impact assessment of our legislation. We legislate and then see the impact falling on the judiciary or the bodies authorized to take upon such action. So this is an issue which you will have to discuss with the judiciary if they would want to increase the number of judges, especially the maritime courts will be in the coastal area where such offences could be reported and tried. Again, this is not a case where this is not an act which will be covering IPC offences. If you recollect the Italian case, the Italian sailors, I think those were, I think, naval personnel. Yes. Under a mistake of fact or mistake of something, they shot dead some fishermen, and they had to be tried as under IPC offences. Now, those IPC this is a piracy bill, so that part is not going to be covered under this bill. So I suppose in those cases, people will still have to go to the regular courts. It will not be covered by designated courts, because that is not a coverage under this bill, sir. Again, your section clause 11 says there's a high level of presumption. Anybody caught with ammunition is deemed to have committed an offense under this act. Now, arms, ammunition, explosive, other equipments, there's evidence of force, threat, and all that. The problem here very often is you are catching somebody on the high seas. He's carrying ammunition. How do you prove that this is for piracy? And especially when it's caught, when you are talking of the suspicion provisions. So there is no offense happened. There is no evidence of abetment happening also. But you have only caught a ship on the high seas where some people are moving suspiciously, or maybe they're carrying weapons, but carrying weapons for their own protection also is not unusual these days. So that's what I'm trying to say, that these provisions of presumptions sometimes become very harsh. And what happens here is, if I am caught on the high seas by the Indian personnel, I'm just saying as a matter of record, if I'm caught on the high seas, I have a couple of guns with me, and it's presumed that I'm a pirate. It will be presumed that I'm a pirate, and I'll be indulging in an act of piracy. Now it is for me to prove my innocence. If I can't prove my innocence, then I have to be convicted, and that conviction is going to be 10 years. So, as I said, all these provisions are good to read and to look at. But the moment when it comes into practice, we know that it's not easy. And especially your bail provisions. Now, in the bail provisions, I don't know why, this twin test, which is being deprecated by the entire legal community, even the Supreme Court judgment in the PMLA case is now being reviewed at the behest of the Chief Justice's order after the judgment. Now, we again come back with the twin test. Now, the twin test is, sir, that if you ask for bail, and in that bail application, if the prosecutor says there's a reasonable ground for believing that he's not guilty, which every prosecutor would say in every case, that I have full grounds to believe that the man is guilty, and then it says, and that he's not likely to commit any offense while on bail. Now, how can anybody, in what way can I prove to the court that except by giving an affidavit or a word or a bond, that I will not commit an offense? Now, on this ground, these twin test is being criticized everywhere. Bail, as a matter of fact, is a rule, as Justice Krishna Iyer would say. Bail is not a trial. You're not imprisoning him for an offense. You only caught him for investigation. Now, once you've completed your investigation, put him to conditions so that he can't run away, so that he produces himself for trial. But the problem here is, as in earlier cases, in earlier legislations, we incorporated this twin condition. Mechanically, I think this twin condition has again come in this act. And again, in many cases, it will become highly difficult, and it will cause great concern and great problems to people who might get even on suspicion arrested. So I'm arrested on a suspicion. That suspicion cannot be proved beyond, then it is presumed, because I'm carrying ammunition in the high seas, that I'm a pirate. I have to prove beyond doubt that I'm not a pirate. And if I don't prove beyond that, I can't even get bail. So these are very strong provisions. Somewhere the magnanimity of law, the largeness of law, and the jurisprudence which the common law gave us, that a man is presumed to be innocent till proved guilty, it has to be followed to a large extent. And with these words, I would say that there is nothing to really oppose the bill, because all these issues are also before the court of law in some way or the other. But it's a step forward. From 2012, an effort was being made to bring this law. It went to standing committees. It went to various discussions in the parliament. And finally, in some shape, at least it has come. And India would be delighted to have a law on piracy. But I would say, please have a look at some of these harsh provisions, whether they would be causing more mischief and damage than doing good to the polity as such. Thank you.
Thank you. Mani Shri Prakash Javadekar ji.